if simply enumerating the powers of government and presuming the rest to remain with the people is not a sufficient defense against government oppression, then it is necessary not merely to have clauses enumerating the rights which the government must not infringe on, but also to have other restrictive clauses regarding activities the government may not engage in, irrespective of whether or not these activities violate any rights. Some such clauses may require caps on government spending, or balanced budgets, or prohibitions on the government's ability to print money. Not all of these are direct invasions of individuals' property rights. For instance, if the government prints another piece of paper, that does not directly diminish how much property any subject of the government holds. However, it does dilute every individual's purchasing power if the government prints enough of these pieces of paper. So it would be prudent to bar the government from having this ability so that the potential for abuse is eliminated. Although these clauses do not immediately concern individual rights, their ultimate object is to hamper the government's ability to develop the de facto capacity to violate these rights. Now, effective bills of rights and restrictive clauses need to incorporate a provision akin to the Ninth Amendment in the U.S. Constitution, which states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This is a very important clause because it states precisely that just because we have enumerated certain rights in this bill does not mean that there aren't any other rights, and that the government can go ahead and claim, well, the protections you believe you're entitled to are not listed here, so we can go ahead and trample on them. Now, some have been pessimistic about how the Ninth Amendment has been applied throughout history. Walter Williams, in 2000, wrote that if any appellant's lawyer argued Ninth Amendment protections on behalf of his client, he would be thrown out of court if not disbarred. That's what the Ninth Amendment has come to mean today. So Williams believes that the Ninth Amendment hasn't really stood up in courts, and that it has failed as a useful defense of individual liberties. Now, with all due respect to Dr. Williams, I believe he's mistaken here. He would have been correct if his remarks had referred solely to the period from the ratification of the Constitution and the Bill of Rights to 1965, where there were a total of only 9 cases that referred to the Ninth Amendment within the Supreme Court's jurisdiction. However, after 1965, there were actually over 1,000 cases which invoked the Ninth Amendment. The turning point for Ninth Amendment rulings was the 1965 case of Griswold versus Connecticut, which involved a very laudable action on the part of the Supreme Court in overturning a state prohibition on the use of contraceptives. The state of Connecticut had a law saying that individuals may not use contraception. The Supreme Court ruled that there exists a right to privacy, not enumerated in the U.S. Constitution, but nonetheless a natural right, which rendered such a state law null and void, and contrary to the Constitution and the spirit of the Constitution. So there we had the Ninth Amendment in action. And since then, we've had a burgeoning use of this very important protection for individual liberties. Now, in a constitution of my own authorship, the Freecharter, which I intend to be less vulnerable to abuses of power than the U.S. Constitution has historically shown to be, I incorporate an even stronger provision akin to the Ninth Amendment. This is Affirmation 30 of Article 1 of the Freecharter, which reads, "The enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by individuals. No individual may be denied the ability to assert his or her possession of rights not enumerated in this Constitution, and to present this assertion of rights before a court of law, which that court shall be obligated to consider in accordance with reason and the objective facts of reality. A court's action in striking down a statute based on this affirmation of rights is not a usurpation of the role of the legislature. So this affirmation takes all of the protections entailed in the Ninth Amendment and takes them a step further. Historically, the reason why courts have hesitated to consider the Ninth Amendment was because they feared that doing so would entail legislating from the bench, and justices have typically been very hesitant in, quote, usurping the role of the legislature. Well, Affirmation 30 gets around that by explicitly stating in the Constitution that when the court makes a ruling on unenumerated rights, it is not usurping the role of the legislature. In fact, it's performing its duty to judge and interpret these claims of rights in accord with reason and the objective facts of reality. Because ultimately what a constitution is supposed to do is not just be self-referential, but to create a political order based on reason and based on justice, where every individual's natural rights are respected and protected. This is why a government is established in the first place. So, I encourage you to take a look at the Freecharter, which is linked in the references section accompanying this presentation, because the Freecharter is designed to overcome all of the disabilities that the U.S. Constitution has been shown to have throughout our quite lengthy experience with the growth of state power. Now, unlike the U.S. Constitution, which includes a Bill of Rights as an afterthought, which wasn't intended to be there in the first place, the Freecharter puts the Bill of Rights at the very top, in Article 1, and Article 1 may not be amended at any time. Moreover, Article 1 is followed by Article 2, the restrictive clauses on government. And as you will be able to see, there are many more rights enumerated in the Bill of Rights. There are 32, and none of them are FDR-style positive rights. And moreover, in the restrictive clauses, there are 39 restrictions on what the government may not do. And I've tried to encompass virtually all possible powers of government that could be abused and that could result in a government that violates its basic purpose, which is to protect the liberties of individuals. So I encourage you to take a look at this document. Hopefully someday it can be applied to an actual human society. But in the meantime, it is a very useful blueprint for what a free society with a constitution could look like. Thank you very much, and I hope that your rights and my rights will continue to be respected and protected.